indicated, we're here to hear the oral argument in the state of Ohio versus Richard Malson. That's our case number 29310. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do wish to reserve that time, if you take the podium, let me know how much, and I'll do my very best to try to keep you apprised. You can see there's also a clock on the wall.
Thank you.
The arguments are being visually and audibly recorded to be posted online, so please keep your voice up and remain behind the podium. We've read your briefs and we are ready to proceed when you are. I will give you one word of caution just because sometimes counsel becomes confused. That 15-minute timer on top is the totality of your time, including what you would reserve for rebuttal.
Okay.
All right.
Great,
Take
thank
the
you.
podium.
Should I begin?
You sure can.
Judge, we'd like to reserve 5 minutes for rebuttal.
All right, thank you.
Judge, there are Your Honor, there are 3 assignments of error. I'm going to start off with assignment of error number 3, and that was whether or not the state met the burden of proof to prove that the threshold requirement that the test was completed in compliance with the Ohio Department of Health regulations and the codes. This is governed by Schindler. The state says that it wasn't specific enough and that they didn't have enough notice. They didn't know what the found. And in Schindler, with the Supreme Court case, the defendant, the lawyer, took the verbatim out of a horn book, copied what the motion was, and then attached it. No specific, no facts, no nothing, just took it and filed it. And the Supreme Court said that's enough because it puts you on notice. It's specific enough. In that case, it's very similar to this. There was a suppression, defendant lost, went to trial, defendant lost, and then they filed the appeal. And I would submit that's the case here, Your Honor. And then Guadalupe pretty much verified that. And what they said basically was that the suppression was meant to just get the ball rolling, put the issues out there so that everybody knows what's going on, and to let the court know that the defendant intends to have the state meet its legislatively mandated burden of demonstrating compliance with any and all challenge regulations and requirements. And I believe we did that, Judge. Now, we didn't...
So let me ask you a question.
Sure.
During the course of the hearing, I mean, it was a pretty lengthy hearing, what happened with regard to testimony or evidence or cross-examination regarding the breathalyzer test and the administrative code?
Well, Judge, first of all, before we filed this, we went to back and looked at the machine. And we saw what we thought were concerns, and we knew that then we would challenge it. We just don't file these every day. And I expected the prosecutor to put evidence on it, and they ignored it. They didn't put any evidence on it. And it's not that hard to do, Judge. Officer Riley was there. He said, I'm not in charge of the machine. The trooper Castillo had never been there before. This is the first time she ran this breath test. And she can run it because she's a senior operator, and she knows how to run this machine. It's the same in the state of Ohio. But not one thing was said about the logs, the 192-hour calibrations, the RFI detectors, anything that we raised. And all they had to do was subpoena the officer who was in charge of that, because one officer always does this to make sure they meet the 192 hours so that the breath tests are okay. And during that time, he marks in the calibrations, and he marks in that this is done. And he marks in that the solution came in on this date, and it's good until this date, and then he's responsible to change it. And he marks in where the solution came from, what the values are. When he does his calibrations every 192 hours, whether it's within 0.005.
So you're telling me none of these issues were addressed during the suppression hearing?
The prosecution presented no evidence whatsoever.
Okay.
Okay? And again, I was a little surprised. What the prosecution did do, Judge, was he said to the trooper, was the machine working okay? Yeah, it was working okay. And in cross-examination, I said to the trooper, do you have any scientific training? Do you understand how the machine works? Are you qualified to render that opinion? And she said no. And then the prosecutor also asked Officer Riley from Bath, who admitted he wasn't in charge of the machine, whether he saw any problems with the machine. He said, no, it looks good to me. But he wasn't qualified either to do that, Judge. So, Judge, once we raise those issues, the state has the burden of going forward and putting, addressing those issues. And because some of the issues were complicated from a scientific point of view, in our motion, we explained metrology and linearity and traceability and those concepts. And the reason that we did that is because I know, as a defense lawyer, that it took me a long time to acquire that information, and I wanted to make sure that there was an explanation of what we were really looking for, so that it aided the prosecutor in that. We gave them the roadmap. They chose not to follow it or present any evidence. I think those tests are out.
Was your motion to suppress specific on each of these issues?
Yes,
It was.
it listed them, yes. Okay. Let's see. We've got 5 more minutes. So, Judge, I think in the mere fact that the state didn't present any evidence, I think they conceded that the BAC test was not done properly, and it didn't rise to the level of being a valid and admissible test. And I can only conclude that because when we did see issues with the machine at the station, they may have seen the same issues and just decided that we were right. I don't know. I don't know what their reasoning was, why they didn't address the issues. But if the burden was on them, they failed to do it, and I don't believe the breath test should have been suppressed, Judge. If I could move on to the field sobriety testing. Judge, I think it's very unfortunate that the manual doesn't get introduced all the time. The manual tells you what the standards are. It explains everything in detail. And I think a lot of times judges are deprived of having that knowledge so that they can make a good decision. And I think that's what happened here. The testimony that did come in from the trooper was good testimony. She said, this is how I do the HGN, the eye test, okay? It's their most reliable test, it's their best test. And she said, I do this many passes, and I do this hold, and I do them in these sequence. And, but if you look at the video, she didn't do it. Even if you think that there's a standard that was established through her testimony, she didn't comply with her own standard, okay?
So the video contradicts her testimony?
Very much so. And let me give you some examples. There was a height disparity. Under the manual, you're taught to sit the person on a bumper so that you can be eye level and see the eyes and see the nice figures. That wasn't done. The trooper said, you must do them in this sequence, okay? And then she changed, she didn't do them in the sequence on the video. On the video, she did them out of sequence. And in direct testimony, or my cross-examination said, if you do it out of sequence, they're unreliable, renders them unreliable. There is a requirement to medically qualify a candidate under NHTSA guidelines. And the reason being is troopers or officers aren't qualified to make a judgment call as to whether they're seeing a medical condition or intoxication. So it's a simple qualification. You ask them if they have any recent head injuries, any inner ear issues that would prevent them from being able to take the HGM. All right. In this case, and then you do 2 more things. Okay. You check for resting nystagmus. Okay, because that's a sign of head trauma or a tumor, and then you check for equal pupil size, because that's also could be in medical. And if you see any of that, you stop. You don't do it because you know your test isn't going to be reliable. Trooper Castillo said that, and we know that. I know that. Okay? But then she went ahead and did the test without the proper medical document or qualification. So she says, if I don't do it, it's not a reliable test, and I shouldn't rely on it. I will also tell you that had the manual been introduced, the manual itself says, you can go ahead and do the test if you don't medically qualify, but you can't rely on it. It's not admissible, and you shouldn't rely on it. And she was pretty honest. She gave us that. You know, she gave the guidelines. She knew. And the medical question that she asked is, have you had any recent injuries to your body? Well, Mr. Malson hadn't, so he said no, okay? Then later, when he realized he's got to do a walking and a balance test, he says, you know, I got this dizziness disease, vertigo. And all of a sudden, she steps back and she gets upset and says, why didn't you tell me that earlier? Well, he didn't think that she was asking about that. Have you had any recent injuries to your body? No. Okay? And the reason being is because she knew that vertigo would prevent getting good results on any of these tests. because she was trained that way under NHTSA standards. And she said in her testimony, these are not reliable tests if the person has vertigo, okay? You're not gonna get a good result, a reliable result. So she was pretty honest about that, and I appreciate that. So I believe the field sobriety test should not have been admissible either. And just to go back before the field, 32 minutes, the Bath police are on scene. 32 minutes, they're doing the accident investigation, they're waiting for them. The Bath officer has intimate contact with Malson, talks to him, exchanges information, he asks him questions. Not one time did he say anything except for I smelled a faint odor of alcohol. And I asked him this question: you can conduct a DUI investigation, can't you? Yes. And I said, and if you notice signs of intoxication, you are obligated to conduct that investigation. He said, absolutely. He didn't do it. He didn't see it. She comes 32 minutes later. The only thing that she's told is there's a slight odor of alcohol, and then she decides to conduct this investigation. I'm going to save my time if I could here. Thank you.
Good morning, Your Honors. Brian Bremer on behalf of the state of Ohio. I had one point of clarification about the procedural history of this case, which is that after trial, there was an attempted appeal, it was dismissed. There was an attempted appeal, it was dismissed. On this third appeal, much like the Tower of Monty Python, we think we have a final appeal order, and we can have the case here now. Another point I want to actually make about this situation here is what is the actual scope of the appeal? Because one of the issues that's raised in the reply brief is that the challenge that's being raised is for the admissibility of the evidence at trial as opposed to the probable cause of the stop or the arrest itself. And what I would say is that's not, I don't believe that was actually the argument that was raised in the brief that was filed, the initial brief. And I don't believe that's consistent with what was going on in the motion to suppress, at least with regard to the field sobriety tests and with regard to the breathalyzer. What was going on in those cases, in those situations where they were, if you look at on page 17 of the motion to suppress, he says that the testing should not be used as a basis for determining probable cause to arrest the defendant for OBI. He does not say that, he's not challenging the admissibility of the evidence at trial, he's challenging he's talking about for the purpose of probable cause. And so when he's now trying to talk about what could or could not have been admitted at trial, this all falls within the scope of the idea that you need to object to evidence that's coming in at trial at the time it's being submitted. Because the court could be reconsidering the decision to admit some of this evidence based on what it was hearing at the trial at the time.
You're talking about Hagerman.
I am, yes.
Has any other court ever cited Hagerman?
I don't know that. I do not know that, Your Honor.
It's a little bit apples and oranges because challenging probable cause, well, never mind, go ahead, just go, I don't want to take up your time.
And one of the issues that he actually raises in his reply brief is that under State versus French, he said, well, the Supreme Court has said that a pretrial motion is sufficient to preserve the issue of the admissibility of the breathalyzer test and some other issues. That is true, that is what the court in French said, but the issue is a little bit more nuanced than that. In French, the issue that was directly before the court was what happens if the defense attorney does not raise the admissibility of the evidence in a pretrial motion. The defendant in French did not do that. So therefore, what the Supreme Court held was that the issue was waived, and you can't then subsequently raise it at trial or on appeal. And then the Supreme Court was citing the previous cases about whether or not the pretrial motion could preserve the issue. In those previous cases, those were following a no contest plea. So what happened in those there was they were not trials. They were some had the motion to suppress. It was denied. They pled no contest. Then came up on appeal, and the Supreme Court said, yeah, that's an appropriate procedure. You can challenge that. That's different than what was going on in this case, which was the motion to suppress was denied. he went to trial. We don't know what happened at trial because the transcript's not before the court, and therefore it was not clear whether he objected and preserved the issue. We don't know what was presented at trial as far as there may have been additional evidence that wasn't at the suppression hearing. And I realize that's speculative, but that's why the record needed to have the transcript of the trial, and that's why you need to object at the time, because it might alter the determination. The other issue that I wanted to point out was that Mr. Quinn has argued that, or has asserted that the defendant in this case had raised the issue about his vertigo during the walk and turn test. That's not precisely accurate. He actually conducted the performed the walk and turn test. When he was asked to do the one-leg stand, that's when he raised the issue about him having a dizziness disease, is how he described it to the state trooper. The state trooper that did respond, saying, "Why are you saying this now?" Because she had asked about medical conditions, and so the exchange happened at a little bit at a different point in time. So it wasn't that she conducted the walk and turn after finding this information out. It's that she found some information out afterwards, and then she did conduct the one-leg stand. It's also important, I think, to keep in mind what in here. There is a significant amount of evidence in the record about what the NHTSA manual says. There's a significant amount, and it actually comes out more on cross-examination than anywhere else, where Mr. Malson's counsel questioned extensively the trooper. What about, does the NHTSA manual say this? Does the NHTSA manual say this? Does the NHTSA manual say this? And she's typically answering yes, or sometimes she's clarifying a little bit, but for the most part, they're laying out what the NHTSA manual provides. And she says specifically, I conducted these tests in compliance with my training, which is the 2015 NHTSA manual. So based on what was going on at the trial here, there's a significant amount of evidence for the court to actually consider what the NHTSA manual had and whether what occurred was in substantial compliance with it. And in this case, the court concluded that it hadn't done substantial compliance. And there's evidence to support that. There's evidence to that she performed it as she should have. And under these circumstances, the court correctly denied the motion to suppress. Now, again, that's what I believe is the actual assignment of error, both for the first and the second assignment of error. It was whether the court, when looking at the probable cause and the suppression hearing, what the evidence was there. In the reply brief, they raised the issue that, no, it's about the admissibility at trial. And that was encountered to the point we were making, that you can't argue about the probable cause and you can't argue about the field sobriety test if you don't actually show that there is actually that they actually mattered. Like basically, if you ignore the field sobriety test, was it still probable cause? We argued that there was, and we point out the fact that he was engaged in a single car collision, and that prior to the accident, there was indication of slurred speech, and that he had no odor of alcohol coming from him. He also admitted having 3 beers. There was evidence here that would support the probable cause finding that he had operated a vehicle while intoxicated. Therefore, any issue about the field sobriety tests would actually be harmless and not really an issue on appeal. Mr. Molson's contends, well, no, we're actually saying that the field sobriety test shouldn't have been admitted at trial. And again, that goes back to the fact that if that's true, we need to see the trial transcript. We need to know whether it was objected, whether it was preserved, and we can't do that because it wasn't. It's not part of the appellate record. So so for those reasons, the first and second assignment of error should be overruled, either because the tests were conducted in conformance with the NHTSA manual, whether there's still probable cause to arrest, therefore making the issue a moot point, or because the trial record isn't before you, so you can't determine whether or not the issue was actually preserved at trial about the admissibility of the field sobriety tests. With regard to the breathalyzer,
Let me ask you a question about that. In terms of putting aside perhaps the differences between the original brief and the reply brief, and whether reply brief would figure in more consideration if it changed subjects. And I don't know if it did. I'm going to go with your argument. Under the new, that aren't so new anymore, rules regarding motions and limiting and making that argument one time pre-trial, would he have been obligated to preserve it by objecting again?
Yes, Your Honor. You would need to, the motion to eliminate is still, it's a final appealable order when it comes to the prosecution, because if prosecution certifies it, because we don't get a second bite at the apple, is it where if we go through a trial and the case is, and the defendant is acquitted, well then, double jeopardy includes the retrial. However, for the defendant, that it is not immediately a final appealable order. You can bring it into trial, and there might be information that's coming out of trial that changes what the court's thinking about what's going on. Maybe someone says something on the stand that makes it very clear that they had misrepresented themselves at the suppression hearing. Maybe there's additional information from another witness that makes the court realize, no, I guess I misunderstood something. And under those circumstances, there should have been an objection to the evidence coming in at that point, and you could move to reconsider it. If the decision was actually final, then you wouldn't be able to do that. And I do believe that that would be an appropriate
Well, the
action.
court can change its mind, and he could challenge it if something happened and ask the court to change its mind. But then you lose the arguments solely because he didn't challenge it again in the future. If that question makes sense. Say, doesn't the evidentiary rule say that you don't have to keep objecting to the evidence that you initially objected to?
I believe that you don't need to continually object every single time, Your Honor, but you do need to object during the trial. And the motion to eliminate is only a interlocutory order that's preliminary in nature. And in this case, and while the courts have said you can then preserve it if you don't go to trial, you still need to actually preserve it if a trial actually occurs. Briefly, I'd like to address the issue about the motion to suppress and the argumentation that we're making about the specificity. The motion to suppress in this case was very, when I say very basic, I don't mean in its entirety. A lot of it actually is a very thorough motion. But there's significant portions of it that, frankly, was one of the more detailed ones that I've seen. But the portion that we're talking about is the part about the BAC, the breathalyzer test. That's where all of a sudden all the specificity fades away, and it just becomes a list of basically saying you didn't comply with this section of the Ohio Administrative Code, this section, this section, this section, this section, this section. It just goes on. And at that point, when you plead everything, you're not pleading anything with specificity. And that's the holding of the second district got reached in the case of State versus Tyner. And they said while you don't need to be absolutely specific, have exquisite detail, you do need to do something more than just wrapping the Ohio Administrative Code in a folder and filing it. And that's what happened here as far as the breathalyzer test was concerned. Was just every single part of the breathalyzer code was put into was listed and then just submitted to the court, which doesn't really put the prosecution on notice about what is being challenged. It's just saying they think everything is they're just saying everything possible under the sun. I do not believe that's the holding in Code Lupi. Code Lupi obviously gives some leeway about the specificity that you need, but at the same time, Tyner came out after Code Lupi. It applied Code Lupi. And it said that you still need to do something a little bit more than just filing a very blanket motion in this case. The motion that was filed here could have been filed, and I recognize what appellate counsel has said, that he doesn't file these every day, but you could file this in every single case. You could, in any case involving a breathalyzer, you could file the exact same motion. And if this court is going to say that that's specific enough, then that's going to be something that probably is going to happen in every single case, is just this motion. Because there's no detail here about really what's going on. I think that would give rise to the belief that there's actually an issue. Just saying, we don't think you did this, we don't think you did that, we don't think you did this. Again, I don't believe that's the purpose of Code Lupi, and I don't believe that that's the, and I don't think that that's the idea of saying that you have to give some leeway on the specificity issue. But appellant has pointed out that this court has addressed this issue in some other cases, State versus Rangel, State versus Slates, State versus McCall. I would point out that Rangel and Slates predates Code Lupi, I believe, but then Slagle Regal, actually, there's no indication in the actual decision that the prosecution was raising a criminal rule 47 issue in that case. The court conducts an analysis that could possibly be construed as that had been raised, but it's not clear that it was. So I would argue that Regal is distinguishable on that basis, that it does not seem like that issue was directly before the court. McCall is a little bit more on point, but McCall does have only challenged a smaller section of the code, it seemed. It seemed like, I believe it only challenged 3 sections of the Ohio Administrative Code, not all, like, not 16. As I pointed out in the brief, the motion to suppress lists 20 issues, like 20 ideas, like code provisions that they say that the state violated. And even on appeal one, it's been narrowed a little bit, it's still at 11. This is basically a shotgun approach to these motions to suppress, and they should not be encouraged, and I don't believe that they're in compliance with Criminal Rule 47 loopy. But I also recognize that that is an issue that this court is in a position to resolve in this case. If there are no further questions, we respectfully request that the decision of the trial court be affirmed and all these items fair be overruled.
Thank you.
Shotgun approach, it's exactly what Schindler was. Took it out of a hard book, plastic cut and paste, put it in, passed the muster. Okay? This was not a shotgun approach as far as the meat of the motion. Yeah, there were a lot of issues raised, but as a lawyer, you have an obligation to raise those issues unless they've been resolved through discovery to protect your client's rights. There's no doubt that foundationally that the state must prove that the machine was in proper working order, no testimony about that. That the test was conducted in accordance with the Ohio Administrative Code, Chapter 3701 to 53. That's Burnside, no testimony about it. That test should go out. And they had an opportunity to raise this issue before we started the suppression, and Judge Larson said, hey Pat, what are you going to do? And we clarified it, we narrowed it down. The prosecutor agreed to that and went forward. So as far as I'm concerned, they waived their 47 arguments. Judge Jez, the State versus Kerr says, there's an exception to the general rule for motions to suppress breathalyzer tests, which makes their denial a final appealable order. Don't have to keep objecting, okay? We wanted to appeal the trial ruling, or the jury trial. We couldn't, no transcript. It's the first time it's ever happened to me. And we thought long and hard about it, and we decided that we had to appeal. This was all we could appeal.
When no transcript was made of the trial?
There were some electronic issues or something, Judge, and we couldn't get it. I sent it over. The reason the appeal was filed, the Smith file dismissed, is because I think her name was Gwen, the court reporter. Said, Pat, there's nothing on this thing. How are we going to transcribe this? And I said, well, wait a minute. Let's go back to the court and see if there's something. And the conclusion was that there was some technical difficulties. We couldn't get a trial transcript. And I can't tell you whether I objected or not. I don't remember. So I can't tell you that. And Mr. Brenner was absolutely right. It was when she started the walking turn. I mean, the one-leg stand that he disclosed that he had a vertical problem. The officer said, here's the here's what you got to prove. I'm sorry. I got it here. Okay, she said, to be standardized, you got to give the correct instructions. She did not do that. She didn't ask for correct medical qualifications. She didn't do that. Correct number of phases. She did the correct number of phases, okay? Stimulus in the same plane, she did that. 12 to 15 inches away, she did that. Correct number of holds, she did not do that. She testified to a 4-second hold on maximum deviation, she did not do that. She testified to a 4-second hold on onset prior to 45 degrees, she didn't do that. And she said correct sequence. Sequence is equal tracking, smooth pursuit, onset, or distinct and sustained nystagmus of maximum deviation, and then onset prior to 45 degrees. Okay, and then there's a vertical at the end, but it's really not part of the test. In the middle of the testing, she does a vertical. I said, not supposed to do that, are you? No, it's supposed to be at the end. okay? And she gave the order. She said if it isn't done in the right order, then it violates standardized field sobriety testing. So she gave it to us. And even though we don't have a manual, she told you what it is, if you believe that that's.
Counsel, let me ask you a question.
Sure.
It seems that your argument regarding the violations that, sounds like she may have made it throughout the way. You're basically telling us she didn't strictly comply. Is
No.
that the standard?
No, it's not standard, it's substantial compliance. But I asked her, I said, what do you gotta do to substantially comply? It's in this transcript. And she gave me her thoughts about substantial compliance. All right, Judge, before you can start a HGN, you have to have a medical qualification. She didn't do it. She admitted it. Okay, that's before you start. Then she admitted that she didn't do it in order, and she didn't do the holds. So you know, these aren't little things. These are big things, okay? And she said if you don't do it right, they don't count, okay? So I think that Judge Larson should have thrown out the field sobriety test and should have thrown out the breath test. There's absolutely nothing in the record that could justify or meet the standard required once it's raised from the state of Ohio. Thank you.
Thank you both for your presentations. We'll take the matter under advisement and issue our written decision.